that this case is not maintainable as there is no such a ground for further argument. The case has decided satisfactorily by the High Court of Saurashtra. The act of telephone tapping is unconstitutional and not consistent with the fundamental rights. My Lordship, may I proceed for the judgment of issue? My first issue is the publication of the private conversation is violation of one's right of privacy. Under Article 21 of the Constitution, the right to life and personal liberty has given as a fundamental right to every citizen. In the Kharasmi versus State of UP, AIR 1963, the Supreme Court has decided that has been recognized right to privacy as a fundamental right. Another case, R. Rajgopal versus State of Tamil Nadu, the same principle has been recognized by the Supreme Court of India. And in People's Union for Civil Liberties versus Union of India, AIR 1996, Supreme Court released 568. The court said that a citizen has a right to safeguard the privacy of his own, his family, marriage, procreation, motherhood, childbearing, and education, among other matters. No one can publish anything concerning above matters without his consent, whether truthful or otherwise. If he does so, it is violation of that concerned person's right to privacy. As in India is a signatory of UDHR and ICCPR, no one in that conventions, no one shall be subjected to arbitrary interference with his privacy, family, home, correspondence. And if it is, then everyone has a right to protection of the law against the interference and attack. If my Lordship, if the court is satisfied with my first issue, may proceed. The government can be liable for negligence as her private conversation has been leaked and published in a leading newspaper. Yes, the government has highly negligent in keeping the records with due care and caution. If the government, in its own capacity, collected the evidence by the phone tapping or interception of phone tapping before proving it as evidence before the court, here the behavior of the government is just like damage to the respondent's reputation, and hence government is liable for handling or keeping the records of that evidence. If the Honorable Court is satisfied with the second issue, the government has no right to record a private conversation, especially for such a long duration of 300 days. In the People's Union for Civil Liberties versus Union of India, AIR 1996, the court Supreme Court given certain directions for the interception of telephone tapping. May you please see the fifth direction which was given by the Supreme Court, that is that the order under Section 5 subclause 2 of the Indian Telegraph Act 1885 shall, unless renewed, cease to have effect at the end of the period of 2 months from the date of issue. The total period if the authority which issued the order may at any time before the end of 2 months period renew the order if it is necessary, and the total period for the operation of the order shall not be at least 6 months, that is 180 days. So here, the Supreme Court directives had not been followed by the state of Saurashtra, and the procedure which was followed by the state of Saurashtra is not just fair and reasonable under the guidelines of the Supreme Court, and it is violation of the respondent's rights. May I proceed for the next issue? Much obliged. If a department of government records a conversation for one purpose, cannot transfer it to another department for another purpose. The government or any department has no right to transfer any record conversation to other department for another purpose. And so here it violates the existing laws and here the government has behaved a very crude manner and has not followed the legal procedure. May I proceed for next issue? The Indian Telegraph Act 1885 permits interception of messages only for the purpose of public safety and public emergency. Hence, violated for any other purpose is against the law. In the People's Union for Civil Liberties versus Union of India, the court said elaborately spoken about the public emergency and public safety. That is, the expression of public safety means the state of condition of grave danger and risk for the peoples at large. And public emergency means prevailing a certain condition of state of affairs affecting the people at large, calling for immediate action. So here, in this case, there is no occurrence of any of these conditions for the phone tapping or interception of phone. it is very clear that respondent is running a business and there is no question of public emergency occurring due to any action of the business strategy. Also, there is no possibility that public safety is at stake. Thus, action of telephone tapping by Income Tax Department or the government of Saurashtra is very illogical and depressing the citizens' right of privacy. Is the Honorable Court satisfied with my application? The action of government is detrimental to growth of trade and commerce and amounts to violation of right to livelihood. Under the case of Olga Kelly versus Bombay Municipal Corporation, court observed that right to live and equally important facet of that right to livelihood, because no person can live without the means of living. That is the means of livelihood. Otherwise, it would mean as a deprivation of the right to life. And under Article 19(1)(g), freedom to practice any profession or to carry on any occupation or trade and business has been recognized as a fundamental right. If Honorable Court is satisfied with my all issues, may I therefore, in the light of issue raised and arguments in others, respondent may humbly and respectfully place before the Honorable Court the further publication of recorded conversation may be stopped with immediate action. The recorded material may be destroyed as earliest. The Honorable Court may kindly dismiss the appeal of the state Saurashtra, or any just order may be passed.
You are saying that Article 21 includes right to livelihood?
Yeah. After the Manita Gandhi versus Union of India, the many rights has been recognized as a fundamental rights by the Supreme Court of India, and right to personal liberty and right to life, it also includes the right to livelihood.
Okay, my query is, you just referred in issue number 1 that the citizen has a right to safeguard the privacy of his home, his family, marriage, procreation of motherhood, childbearing and education, among other matters. How business is covered in it?
Actually, in the PUCL versus Union of India, in that case, is in that case, Honorable Justice Subbarao has been given their opinion that further the right of personal liberty takes in that case, telephone, private conversation for long duration of 300 days. But in the PUCL versus Union of India, the court says that directions which was given by the Supreme Court is that the interception of telephone tapping is not exceed for 6 months and further is not granted by the court. And here the telephone tapping which was done by the state of Saurashtra is such a long duration for 300 days. So it violates the right of the citizen or the respondent.
The two tracts transferred during tapping are published as it is. So how it affects your right? Two tracts have been published or transferred during tapping. How it adversely affected your right?
Yeah, it doesn't matter. But if
How will you answer that you have exceeded the period which has been laid down by the Supreme Court of 6 months?
Maximum 6 months duration is allowed, but then there is a illegal under to the